just need a date to reset it.
Are you available the
14th of July.
I can't set anything up.
Okay, that's all right. Well, I
You can't say anything else.
See how quickly the judge shuts it down? That's a subtle but powerful courtroom move. When a judge refuses to elaborate, it usually means the matter is sensitive and already under careful review.
I still had it down on my calendar. I had it on both.
Apparently, Judge Wallace has advised he cannot say anything else on that day.
In the future,
Okay.
you need another day.
We do need another date just to set it in case we can't agree, but I think we'll probably be able to reach an agreement on it.
I don't think
The
Ms.
judge
Roberts is
compares
available
taking
on
away
August,
cell
the
phones
dates
to the
that we
old
have.
school leather belt.
On the August
Blunt,
dates,
even
those are
darkly
double
humorous,
dates, and
but it drives
I've
home
already
his
got
point.
everything set.
September 3rd.
You also have a Jones versus Jones case that's next, and you have a motion to continue in that.
I do.
Yes. And our only issue, and I don't know if Your Honor reviewed the motion, is the mental health of the minor children. It'd be the only reason that we would need to
What's your
press
reason?
forward.
I haven't looked at the file yet.
Here's the first legal twist. Proper notice. Civil procedure requires 5 working days, not less. This isn't nitpicking, it's about fairness. Imagine being forced into a final exam with barely a night to study.
Under the rules of civil procedure, we're entitled to 5 days notice, 5 working days notice. We were not provided 5 working days notice. I got it at 5:03, emailed to me. And again, just getting ready for it. Ms. Duke has made some accusations that are going to take this will be an all-day hearing.
If I may briefly respond, it was sent by certificate of service on the 18th, and so we complied with the rules of civil procedure, and then I also emailed it at 2:00 on the 23rd.
So
What are
days.
your issues regarding the urgency of it, Ms. Duke, in the Jones case?
A few of the minor children are going to have to be in significant therapy based on the continued threats of the father and the bad mouthing of the mother and some things that he's doing to try to manipulate the children.
And that's contested.
The children are here. If you're
Now the case hits its emotional center, the children's mental health. In custody battles, everything boils down to one guiding rule: the best interests of the child.
And again, the second reason is I had a deposition scheduled with Ms. Duke's law partner at 11:00, but late Friday afternoon, Mr. Vandervoort filed a motion to continue, and we heard that in front of Judge Turnbow, and he granted the continuance. So that was the other reason for the continuance in my motion, but that resolved itself. But it did lead to the fact that I got this and had no time for preparation, and so we just need to continue.
What about the 9th of July?
The 9th of July, I have Judge Lockhart Mashes in Dixon, and I have Carbone versus Carbone.
Give you a date for both of these that you may have to hear it out of county because someone else will be here in July.
Judge, may I approach off of the video?
Mute this, please.
I don't like for everybody to know that I'm going out of town from the 5th through the 12th of July.
That was the reason we were moving Butler.
Yes.
18th.
18th of July.
This is all contingent upon your agreeing to hear it out of county because I'm going to be in Cheatham County, but I have that date available. And other than that, I could give you
As far as I know, I try to keep Fridays
I
open.
could give you the 29th.
The 29th, again, that's Judge Lockhart Mashes, Dixon Chancery, and I have a Bradford versus Bradford, and then a final hearing in a Crispin
Would you
versus.
rather hear this one on the 31st and just bump to the Bates case?
Now, I can do the 18th. I don't know that.
I have a matter that the Hickman County Court set, but I will file a motion to continue on that one. So I can do July the 18th. It's important that this be heard.
And we're doing Butler mediation on the 16th of July. So hopefully we can get a date on it. we'll just work together to get a date on it after the mediation.
All right, so at this point, we're gonna set the Jones case that Ms. Roberts is asking for a continuance on the 18th of July.
Yes, and can we admonish both of the parties to verify that nothing is to be said about this? That is our major issue. The kids are calling and crying, and we would assert that we've got text messages to back up everything that's been said in our motion.
I'm not gonna assume the facts in the case. Are the parents here, both sides?
They are.
Bring them up.
You will keep your hands out of your pockets, please.
Mr. and Ms. Jones, we're moving heaven and earth to get you a date to hear the.
Notice the shift. This is no longer just scheduling. The judge lays down a firm order. Parents must stop discussing the case with their kids. Why? Because children should never be turned into emotional pawns.
Have been made by both sides about the situation. I'm not assuming that any of those facts are true. But what I'm going to tell you is this. I'm putting an order down today that you two are not to discuss this case with the minor children, period. Is there a guardian ad litem in this case?
I think we need one at this point, Judge.
I'm not opposed. I don't know that there's funds available to do it. It's a private case, but if we're never opposed to one, that's fine. We would just ask that both parties be ordered to make a deposit with that guardian ad litem up front.
Well, the reason the guardian ad litem is even being discussed is because of the fact that you've got minor children in the middle of this. You both may be fine people. You both may be good parents in your mind, and that's good. But my main concern and the main issue that I have in this case is to protect them.
Boom. That's the judge's bottom line. Protecting the children comes first. Both parents' pain is secondary when the well-being of kids is at stake.
Yeah, because my interest is trying to protect the children. But by the same token, children are very perceptive and empathetic to their parents. And if they see one of their parents upset about something, then they naturally will, try to side with that parent, and they will naturally try to empathize with that parent. So let's try to shield the children from whatever's going on between the two of you. Let's don't involve the children. And I say it in a very nice way, but I'm telling you, I'm ordering you not to involve these children and not to have the children influenced, not to discuss this case with you about this. If they have questions about it, you just tell them, honey, I can't discuss it with you because that mean old judge told me he put me in jail. You don't have to say it like that, but that's exactly what will happen. If I find out that you two have broken my order, then I'm going to put you in jail because I fully and firmly believe it is in the best interest of your children not to be put in the middle of this situation. Children are, used to having both parents. That's the home environment they had, and now that's blown up. Why wouldn't they be upset? I mean, that's a natural reaction to the fact that what they thought was their cocoon of protection and the home that they had is now no longer there, because their parents can't get along and they're going to go through a divorce. But under the circumstances, you two can still make it okay for your children by protecting them from being exposed to all of the negativity that a divorce naturally brings about. Allegations may be made. Those allegations would have to be proven in court. I understand that children may be called to testify. I think that's a very regrettable, but sometimes a very necessary step to be taken. But that's the reason that I'm considering a guardian ad litem being appointed.
Enter the guardian ad litem, a neutral advocate whose only job is to represent the children's voice in court. Think of it as the child's personal lawyer.
The children need somebody to advocate on their behalf. Now, Mickey Furlong Smith is the one that I generally use in a lot of cases. I would simply suggest, since I've set this hearing for the 18th, that you two need to check with her and make sure she's available. Before, I know she's out of town
She's
right
in
now.
Chicago right now.
So it would be my opinion that you need to check with her and see if she's available on the 18th. If not, we need to get somebody else that is available.
Yes, sir.
And there are other individuals who can do that. Lynn Coffinberry is another one that we use on a regular basis. But let's find a guardian ad litem that's available on the 18th so that we can do
Yes,
this.
sir.
Where are we going to hear this? Which courthouse?
Courtroom 5 in the Justice Center,
In Dix. Okay.
Charlotte, Tennessee.
You just said you were in Cheatham, but you're going to be in Dix.
Right.
And again, in just a some guidance, Your Honor. Again, as you are well aware, children and their electronics to stay or something that I didn't necessarily grow up with, but punishment issues when you're taking electronics away from children because of misbehavior, whatever, does that include cell phones? And then escalates into, oh, you've taken my cell phone away from me.
My client doesn't have a problem with that at all.
So again, it's,
But if she's explained to the children, if you've done something, Dad can take phone away. Yeah, absolutely.
Put it in the court order that one of the avenues of punishment. How old are these children?
they range.
We've got 16 and 11 right now.
Well,
There's a set of twins.
I'm of the opinion that if they are misbehaving and there's some reason to do that, taking their cell phones away is better than having a leather.
Then comes an unexpected moment. The judge compares taking away cell phones to the old school leather belt. It's blunt, even darkly humorous, but it drives home his point. Discipline is allowed. Abuse is not.
Across the rear end like my father used to do with me. So I think that would be certainly permissible, and the children need to understand that is not an abusive exercise of parental authority.
And go call the other one on somebody else's cell phone and say, somebody took my cell phone away, and I made
just put it in the court order that the court authorizes both parents to take the children's phones away if in an appropriate situation as parental discipline.
I will assert with the court that my client has absolutely no problem with that, but it was discovered that one of the children was confiding what was going on in Dad's home, and that's when the child's phone was taken away.
And that is highly disputed with some, and again, that's what they want you to believe, Judge. And I know you're not listening to that, and that's why I ask in a generic sense. I'm not trying to prime the pump that Ms. Duke is trying to do. Yes. It's disputed.
You two are good lawyers, but you are kind of like oil and water. And under the circumstances,
good and bad. I realize that, Judge.
It is yin and yang, is that what you said? And there is some truth to that, whether you like it or not. But under the circumstances, I'm not assuming any of those facts are true. I'm trying to give you an opportunity to be heard, where we can establish what the facts are. So let's just try to maintain the status quo and keep the children protected to the best of our ability until we have that hearing.
Yes,
all right. Thank you.
Thank you.
Thank you, Judge.